Montagno, Joseph Fontana, and John Lobianco on behalf of Mr. Sievers.
And for the record, Mr. Sievers is present. I'll make sure you guys have his headset working properly.
Thank you, Your Honor.
Is it working?
Yes, sir.
Okay. If there's a problem, just let us know. Okay. State's ready to proceed, correct?
Yes, Your Honor.
Defense is ready to proceed.
Yes, Your Honor.
Next witness.
Alicia Cardenas, please.
Right around this way, gentlemen.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Good morning.
Good morning.
Could you please state your name for the record, please?
My name is Alicia, Alicia, Cardenas, Cadenas.
And if you could speak closer to the microphone, it would be appreciated. And where are you currently employed?
I'm currently employed at Signature Science, which has a forensic DNA testing laboratory in Austin, Texas.
Okay. And in what capacity are you employed there?
I am the validation manager and the forensic DNA analyst as well.
Okay. And prior to being employed there, where were you employed?
I was employed at DNA Labs International from January 2014 to June of 2021.
Okay.
And while I worked there, I was a senior DNA analyst, the technical leader, as well as a laboratory supervisor.
And prior to your work with DNA Labs International, were you employed anywhere else?
Yes, I was. I was at the Virginia Department of Forensic Science. I was there for approximately 7 years, working as a forensic biologist in the forensic science section.
Okay. And could you please detail for us what your educational background is?
I received a Master of Science in Forensic Science from Florida International University and a Bachelor of Science in Biology from Nova Southeastern University.
And have you received any specialized training in the field of DNA analysis?
Yes, at each of my positions, I did receive training. At the Virginia Department of Forensic Science, it was a 10-month hands-on training program where I worked alongside qualified examiners and actual casework on training samples that were meant to mimic actual samples. I had to complete a technical oral competency exam as well as a formal mock trial. And then subsequently at DNA Labs International and at Signature Science, I also had to complete training as well as a competency exam.
Thank you.
Your Honor, the state concedes that the witness is qualified to give her opinion in this court.
Noted.
Okay. Now, how did you become involved in this case?
It was when I was working at DNA Labs International. I issued several reports related to this case for evidence that was submitted by Lee County Sheriff's Office.
Okay. So you were initially approached by the Lee County Sheriff's Office to do work on this case?
Yes, they submitted evidence to the laboratory.
Okay. And we're going to focus on two particular pieces of evidence, a backpack and a blue jumpsuit. When were those items submitted to your lab?
Those were received on August 28th, 2015.
And what was your lab asked to do with those items?
We were asked to examine them for the possible presence of blood, as well as to perform or collect a sample for DNA testing and perform that analysis.
Okay. And let's take each individual item. You received a backpack, is that correct?
Yes, that's correct.
What happens when your lab receives an item of evidence?
When an item of evidence is received, it's first logged into our laboratory information management system, which is an electronic system that tracks that item in the laboratory and provides a chain of custody. Each item is assigned its own unique item number within the laboratory. For the actual screening process, the individual screening it will do a visual examination of the item. They're going to document the condition of the package, the condition of the item itself, note any visible staining on it. And in this case, they would perform any blood testing as needed on possible blood stains. And then once that's complete, they will collect a sample for DNA depending on the case information.
Okay. And with respect to the backpack, after the visual inspection, what was noted?
After the visual inspection, blood testing was performed and no blood was detected on the item.
Was there any swabbing or any DNA detected on any part of the backpack?
There was a sample that was collected from the arm straps of the backpack, and the DNA profile obtained from that sample indicated a mixture of at least 3 individuals with at least 1 male contributor, and it was determined to be inconclusive for comparison purposes, which essentially means it didn't meet the criteria in order to use for comparison. There are certain thresholds that would need to be met.
Okay. And just for the sake of the record, to make it complete, could you briefly describe what DNA is?
Yes, DNA stands for deoxyribonucleic acid. It's the material that contains all of the information that a living thing needs to develop and function. You get half of your DNA from your mother, half from your father. About 99% of DNA is the same for all human beings. And about 1% will differ between individuals, and that's where we focus our testing on.
Okay. And in this particular case, you said that there was a mixture involved with the straps of the backpack.
Yes, that's correct. A DNA profile could essentially, when I evaluate a DNA profile, I'm looking to see how many possible contributors are present. It could be a single source, meaning it originates from one individual, or it could be a mixture. And then based on how much, what I'm seeing, I could determine the minimum amount of individuals that could be contributing. And for this particular sample, it was determined to be at least 3 individuals.
Okay. But in the end, you couldn't do an actual comparison with any particular individual with this?
That's correct. The profile was determined to be inconclusive for comparison.
Thank you. And does that mean that there's a threshold that wasn't met in order to be compared?
Yes. So essentially, it could either mean that we're seeing indications of at least 3, but not enough information from all 3 individuals to do a comparison. So I wasn't able to meet that criteria.
Okay. And the other item submitted was a set of blue coveralls. Is that correct?
That's correct.
And was this item also visually inspected?
Yes, a visual exam was conducted. Any staining that appeared to be the possible blood was tested, and no blood was detected on the item.
Okay. So there was no visual blood on this item?
There were stains that were tested. However, no blood was detected. So essentially, when we do a visual exam, we'll be looking for any possible stains that resemble blood or could be masking the presence of blood. So if there's any even dirt-like staining that could be masking it, we may sample to make sure that there's nothing being masked. And also, depending on the color of the item, we may do random samples of the item to see if there's any blood detected as well.
Okay. Was this item also examined to see if there was any wearer DNA?
Yes, a sample was collected from the interior wrists, neck, and underarm areas of the coveralls.
Okay. And did this lead to further analysis?
When this proceeded through the process, it stopped at a point where we determined how much DNA is present in the sample. So at that point, it was determined that no DNA was detected, which means that we weren't able to proceed further.
Okay. And you authored a report on this case with those findings?
That's correct.
And that report was submitted to the Lee County Sheriff's Office?
Yes.
And at that point, were the items returned to the Lee County Sheriff's Office?
Subsequently, it was returned. I don't have the exact date of return in front of me, but it was returned to the agency.
Okay. Were you ever deposed in this case?
I don't have any documentation of a deposition. I'm not aware of or don't recall.
And do you recall if you testified at trial?
I don't believe I did, no.
I'll pass the witness at this time, Your Honor.
State.
Good morning, Ms. Cardenas.
Good morning.
So the testimony that you gave is in relation to your second report, which was provided on August 31st or on or about August 31st of 2015, right?
That's correct.
And you authored several other reports related to this case.
Yes, I did.
How many?
4 reports in total.
And those reports were in reference to other items and not just the backpack?
That's correct.
All right. So you talked earlier that our DNA is what you said over 99% similar.
Yes, for human beings.
So, for example, our DNA determines such things such as eye color, skin color and tone, hair texture, right? Gender.
Yes, so DNA will essentially give information to provide what hair color or eye color we may have.
So you've got greenish, bluish eyes, brown hair, light textured skin, and you're a female. I'm an African-American male. I've got brown eyes, dark curly hair, or what's left of it. And you say, despite our obvious differences, our DNA is 99% the same.
Yes, 99% for all human beings, and then the remaining 1% is where we see differences.
Does the fact that our DNA is so close cause any issues when there are mixtures of DNA, when there's more than one contributor to a sample? And if so, what are those issues?
When we're testing DNA, we are looking at various areas that we know are different between human beings, but there could be sharing of DNA at certain areas. That's why we test multiple areas. So in this case, for example, we use the Identifier Plus system, which targets 16 areas of DNA. So while each individual may share at one area, they overall will expect to see different DNA profiles when we look at all 16 areas. But when we're dealing with mixtures, it does become more complex in terms of how much is being shared, which is something that could lead to why it would be inconclusive.
So if a person was known to have had possession of that backpack and their DNA wasn't found on the backpack or was in a mixture that was inconclusive, what does that mean?
Since the mixture was inconclusive, I wouldn't be able to make any determination as to who could be contributing. In general, DNA, if you come in contact with an item, you may leave DNA behind. It doesn't mean that you will definitely leave DNA behind. So there's various factors that can contribute whether or not you leave DNA behind when you come in contact with something.
And there are factors that affect the presence of DNA on an object, right?
That's correct.
The environment, for one, right?
Yes, that could have an effect.
Humidity,
Yes.
sunlight.
Yes, over time, certain elements could affect how long DNA could last on an item.
And when you say that the mixture of DNA on the armband or the arm strap on the backpack was inconclusive, were you testing that against the standards from Jimmy Rogers and Taylor Shoemaker?
At this stage, I would determine that's inconclusive for comparison. I wouldn't proceed to looking at any of the standards in comparison.
Okay, so because you were unable to develop a conclusive DNA profile from the strap, you weren't then able to compare it against any of the other control samples that were submitted.
That's correct.
So you're not able to say that Jimmy Rogers' DNA was present on the backpack.
I wouldn't be able to say either way.
And you're not able to say that Jimmy Rogers' DNA was not present on the backpack.
That's correct.
You're not able to say that Taylor Shoemaker's DNA is present on the backpack.
I wouldn't be able to offer any conclusion as to that.
And you're not able to say that her DNA was not present on the backpack.
That's correct.
The blue coveralls that you were given, what condition were they in?
The notes indicate that there was debris and bugs present, so it appears to have been out in the elements.
Does being out in the elements, can being out in the elements affect the any potential DNA samples that might be on an item?
It can. It would all depend on various factors. I wouldn't be able to offer, because I don't know the conditions that I was exposed to, I wouldn't be able to offer any information as to what would be likely or not in terms of whether DNA could go away. But in general, being exposed to certain elements can degrade or break down DNA.
And when you said you conducted a visual exam of the blue coveralls to look for blood, how do you conduct that visual exam?
So the visual exam was conducted by another individual at the laboratory, but I do have the notes related to it. Essentially, the item is pulled out in the laboratory in a clean work area, and it's all the notes document the condition of the item as well as where any staining may be present and what would be tested.
Are any alternative light sources or chemicals used to try and reveal any potential biological samples on the item?
In this case, an alternate light source wasn't used. Generally, an alternate light source is used to visualize any stains that may not be visible under natural light. But this could be particularly helpful with semen, saliva, perspiration stains that may not be visible. In this case, it was just a visual exam under regular light. In terms of chemical tests, we did do, the blood test would be a chemical test.
And it's safe to say, unlike the semen, saliva, and other items, blood staining often leaves a visible brownish reddish stain on items.
Generally, yes. There's an appearance of blood that we look for. And like I said, if it could be masked by any type of other staining that looks different, we will test. And also a darker item, so something that's like black in color, we will do random sampling of areas in case we're not seeing something visibly.
And unlike the backpack, on the backpack, you said that there was a mixture, inconclusive for comparison purposes. Were you able to locate a DNA profile from any of the areas you swabbed on the coveralls?
For the coveralls, the interior wrist, neck, and underarm areas were sampled and no DNA was detected.
And why were those, in fact, those areas were sampled because they're wear areas, right?
Yes, it would be areas that may come in contact if you were wearing the item.
And so, for example, the wrists, oftentimes from movement, will leave skin cells on the wrist areas of a garment, correct?
Yes, that's possible.
And on the neck area of a garment, again, from maybe even sweat as well as from skin, from movement, you can leave skin cells on the neck area of a garment, correct?
That's correct.
Does the fact that DNA, in fact, the fact that DNA wasn't found on these coveralls doesn't mean they weren't actually worn, right?
That's correct. When we say no DNA was detected, it means that there could be no DNA or DNA below the detection limits of the test. So there are certain thresholds that are certain sensitivity to the test itself.
Or DNA could have been obliterated by the environment, right?
That's possible.
And so because of the fact that you didn't locate a profile, you weren't able to compare anything to the known standards from Taylor Showmaker, Jimmy Rogers, Teresa Sievers, or Curtis Wright.
That's correct. I wasn't able to draw any comparisons since no profile was obtained or no DNA was detected.
Thank you.
Vince. Is this witness to be released or retained?
Released, Your Honor.
Agree?
Agreed.
Thank you, ma'am. You're free to go. Next witness.
I'm going to be calling Mr. J.D. Thomas next.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Good morning, sir.
Morning.
What's your name?
Joseph Thomas.
And do you from time to time go by JD?
Yes, always.
Mr. Thomas, are you employed?
I own my own company, Forensic Consulting Services.
What does that company do?
Basically, we review and analyze crime scenes, do crime scene reconstruction, bloodstain pattern analysis, bullet trajectory, all sorts of things involving mostly homicides.
Okay. And I guess, is there a subsequent component to that once you do all sorts of those analyses? Do you do anything with that information?
That really depends on the attorney, whether he wants a report or he or she wants a report or just consult. It's basically whatever the attorney needs.
Okay. And how does one come to be so employed? What's your professional background?
I was a police detective in Virginia in the forensic science section. I've been doing forensics now for a little over 39 years, and I have a little over 4,700 hours of training. Member of the International Association for Identification, International Bloodstain Pattern Association, medical investigator for the Florida Emergency Mortuary Operations Response System.
It's not relevant, so I'm not going to ask any more about that, but I am curious. Please go on.
Really, you should. And I mean, if you want to know how I got my start, it was back when I was in the Navy and assigned in Roosevelt Roads, Puerto Rico at the Naval Station. In November of 1978, got a call that we had an aircraft coming in from a place called Jonestown, Guyana. And for the next 10 days, we had over 100 aircraft. And we were, the way it was written was humanitarian relief for deceased American citizens at the People's Temple in Jonestown, Guyana.
Okay. Again, another thing about which I'd like to inquire further, but I will endeavor to keep it relevant. So I guess with all of that background and being so employed, did you ever come to be involved in the Mark Sievers case?
I did.
Okay. And was that for the state of Florida or was that for the defense?
For the defense.
And I guess prior to your formal involvement in the case, what was your relative level of awareness of the incident?
You mean prior to?
Yes, sir.
Nothing.
Okay.
Hadn't heard about it.
You hadn't, I guess, read about it in the paper, hadn't heard about it in the news?
No, I'm 3 hours north, so I hadn't heard a thing about it.
Okay. Still in the state of Florida?
Yes.
Okay.
Tampa Bay.
And so being involved in the defense, were you initially contacted by someone from Mr. Sievers' defense team and asked about your services and brought it that way? Or how would you describe the way you first became involved?
Yes, I was contacted by someone in his office.
Okay. And subsequent to that contact, I guess they decided that they would use your services?
Yes.
Okay. And how does that work with respect to how the court treats you? Are you appointed? Is there any sort of recognition that way in the record?
In a case like this, it goes through the JAC, Justice Administrative Commission. They basically file a motion with the JAC. The JAC signs off on it, then goes to the judge for the order. And once the judge signs the order, it's done.
Okay, when you say they file a motion, is that the party who is
Right,
retaining your
whoever
services?
has contacted me, whoever wants to hire me.
Okay. And so your, I guess, work with the defense team. I guess, how would you characterize the level of your involvement with the defense team?
In this case,
Yes, sir.
I had one phone conference with Mr. Mummert and his paralegal at the time. Everything else was through email between myself and his paralegal.
Okay. And off the top of your head, do you know the date on which the order was filed by the court, kind of codifying your involvement in the case?
September 12th.
Okay. And do you, I guess, file normal invoices with the JAC, or do you, I guess, provide them with anything that essentially reflects the duration of your involvement in the case, or your active involvement?
Yes, sir.
Okay. And do you remember when your final billing entry was for the JAC?
It was September 24th, 2019.
So I guess in total, is that about 12 days?
Well, there was a difference between when the order was signed and when I got the parts of discovery that was emailed to me via Dropbox.
Okay.
So I didn't get those till September 15th. So I didn't begin till September 16th.
Okay. So I guess an association for about 12 days and about 8 days worth of substantive work. Is that accurate to
Yes,
say? Okay. And in those 8 days, roughly how much time was dedicated to investigating
I
this
can tell you
case?
exactly if I can refer back to an invoice.
If that will refresh your recollection, yes,
Sure.
sir.
$47.2 hours.
Okay. And in those 47.2 hours, I know that you had that initial 45-minute conversation with the first chair and his assistant. Was there any more time from those 40-some odd hours that were dedicated to actively collaborating with the defense team and preparing them for how they would use and examine the evidence?
No.
Okay. Let's talk about the rest of those hours then. The rest of those hours, what were they spent doing?
There were a total of 2,284 crime scene photos that I had to review.
Okay.
I got the deposition from the medical examiner, the deposition from the crime scene technician that worked the scene, the crime scene report done by the same crime scene tech, and then the deposition of, take that back. I was provided notes that were taken after the deposition of Mr. Wright. I didn't get the deposition itself, just notes that were taken during that. And then the deposition of Detective Downs, the FBI lab reports, discovery index, depot of Detective Lebed, and then the review and documentation of the deposition of Detective Downs.
Okay. Now, when you say that you received a deposition, is that a transcript of the deposition testimony?
Yes, sir.
Okay. And so you were provided these various pieces of discovery. How did you receive that?
Dropbox.
Dropbox. So it was emailed to you?
Correct.
And you
Now the depot of the medical examiner and the documentation of the notes from Mr. Wright's deposition were emailed directly as an attachment. They were not in Dropbox.
Okay. During your involvement in this case, did you ever have to go to the law office from which the defense team was working to review hard copies of any discovery?
No.
Okay, they provided everything that you needed to see in digital format. Or rather, they provided you everything that you saw in digital format.
Yes.
Okay. Now, besides kind of reviewing evidence and providing any conclusions from that you're able to draw, can you assist a defense team in any other capacity within the scope of your training and experience?
Yes, sir.
Okay. I guess could you provide an example of that?
Typically, we review the theory of the case that is going to be presented, and then based on the evidence, and we see if there's any other plausible explanation for what was where and why it was there and how it got there. Assist in writing questions for depositions, and also for cross-examination for trial.
Okay. So if you have an attorney who's not terribly familiar with the mechanics of physical trauma to an individual, you could assist in kind of lending your expertise
Yes, sir.
to information to help them understand it better, maybe craft better examination questions.
Yes, sir.
Okay.
Your Honor, I apologize. There is an issue with Mr. Sievers' hearing device. If we could just take a 2-second break, see if we could work out this chirping noise.
Took a 2-minute recess to give you time.
Thank you, Your Honor.
Thank you much.
So you can stay there or get up, whatever you.
Another unit too, if we need to use it, switch it out, right? Okay. Well, we can try that if it keeps going on. That's all right. It's not your fault.
Your Honor, she's just out in the lobby speaking to a witness. She'll be in a moment, but I think we can proceed if Your Honor's okay with that.
We're fine.
You're all right with that,
Mr.
Ms.
LoBianco is okay with that.
I apologize. We're ready to proceed.
You're all right with proceeding without one of your attorneys present, Mr. Sievers?
Yes, sir.
Okay, you may proceed.
Thank you, Your Honor. So I believe we were talking about different ways in which you can provide assistance to the defense beyond simply analyzing discovery provided. And I guess just to confirm, beyond your analysis of the discovery provided, was there any other capacity in which you asked to or in fact did assist the defense in preparation for this case?
Again, like I said, it's consulting with for other plausible explanations, drafting questions for cross-examination.
I understand that those are ways that you can help. Were there any of those ways in which you did actually help the defense or were asked to help?
In this case?
Yes, sir.
No.
Okay. And one important thing is, could you have provided such assistance if it was requested? Were you available at that time?
Initially, I was told that the trial was going to be October 1st.
Yes, sir.
And then they asked for a hearing. The hearing was denied. Then the last I heard, they were going to file another motion for another hearing, and that's the last I heard. I couldn't even tell you when the trial began. But at that time, I was available.
Okay. I guess, did you ever become aware of obviously, but when and how did you become aware of the results of the state of Florida versus Mark Sievers trial?
Probably, as far as Mr. Sievers go, probably on the news, because when I go to close out a case, I'll go into the court docket screen. And that's when I saw that the trial had been done over and he'd been convicted. So that's when I closed it. As far as the other two, I don't think I found that out until probably last year.
Okay. So the defense team never corresponded with you either by phone or by email to advise you that you either were not needed or your role in their defense was over?
No.
Okay. Now, what is your understanding of
Excuse me, let me back up a minute. I did get an email in December from Mr. Mummert's paralegal
Mhm.
in reference to assisting them on another case. And in that email, she mentioned that that the trial had been done and that Mr. Sievers had been convicted. So I did find that out in December of that same year.
Okay, thank you, sir. So when you are brought on to the case, what is your understanding of the specific, I guess, thrust of your investigation? What is it you understood you were going to have to do for defense?
Just, again, just review the scene, review the blood stains, and then, the depositions and the crime scene reports.
Okay. Well, did the defense have, or did they express to you any theory that they wanted you to either, support or refute?
The only thing that I was made aware of is that during that time, Mr. Sievers was not present. He was still out of state.
Okay. And so I guess, how did they want that information to be contemplated in your analysis of the crime scene?
That's something I don't ask,
Okay.
and they didn't give to me because I didn't want it.
Okay. All right. And was there anything else that they wanted you to render an opinion on regarding the appearance of the crime scene?
No, like I said, we never had another discussion about it. And that first confrontation, or first communication we had on that phone call, I didn't know anything about the scene to give him any idea at that point in time, and we never spoke about it again. Mr. Muller and I never spoke about it again.
Okay. I guess from the defense team, was there someone with whom you corresponded more frequently than anyone else?
The paralegal, and that stopped on September 15th,
Okay. About 3 days after your appointment?
the same day I got everything in Dropbox.
Okay. And so, I guess, what insights were you able to glean from your review of the discovery provided?
I mean, as far as
As far as what happened on the night of the incident?
she was absolutely brutally attacked with a hammer. That was obvious, as you could tell by the injuries, that it was a hammer. That most of the injuries occurred while she was down low because of the cast-off patterns on the refrigerator. A lot of cast-off patterns in the blood on the cabinets, but most of them were low. A lot of just dripping blood throughout the kitchen floor. So you knew that there was a lot of movement within the kitchen. Didn't tell you who did it.
Okay. How about, maybe not the specific identity of the person, but were you able to glean any physical characteristics of whomever the assailant may have been from your analysis of the crime scene? For instance, height?
No.
Okay. And how about the two individuals who were at that time alleged to have been in the home? They were Curtis Wainwright and Jimmy Ray Rogers. What information did you have about either of them?
Nothing that wasn't included in the reports that I got.
Okay, so for instance, their respective physical conditions, any injuries, anything like that, you had no awareness of?
None, no.
Okay. And you mentioned that there was blood dripping, blood splatter throughout the home.
Spatter.
Spatter, thank you. Was there, as far as you can recall, any measurements taken of any of the blood spatter? Meaning, the diameter of any of the specific blood drippings, such that you could determine the height from which they fell?
No. Again, I mean, they were marked correctly, but as far as I don't think that any actual blood stain analysis was ever conducted.
Okay. So, I guess, how clear a picture of what you were tasked by the defense team to accomplish did you have?
Again, I'm the old school believer that forensic science is not for the prosecution or the defense. Therefore, I really don't care and I don't want to know what you want me to tell you
Mhm.
because I don't want to hear it. Let me do my thing and I will tell you what I find out.
Okay. And I guess, did you find out anything that determined conclusively the number of assailants involved in the incident?
No.
Okay. And how about with respect to the injuries on the deceased? Do you recall their general appearance?
Yes.
Okay. And as far as you can recall, can you describe them?
Most of the damage was impact, blunt force, like half moon that you would see when the like half of a hammer makes contact, and that could be either from the way it strikes the surface or the curvature of the skull when it struck, is why you don't have that full head of the hammer showing. And then a lot of it, you have damage being caused in areas already damaged. So you don't have that half moon shape anymore. Now you just got more of a crushing because it's already hitting areas that have already been broken.
Okay. Was there anything from what you reviewed that cut conclusively in favor of the defense or the state? Meaning, is there anything that you found that supported, for instance, exonerating Mr. Sievers versus proving conclusively the state's theory?
I mean, the only thing is that he wasn't there. I mean, other than that, as far as the conspiracy, there was nothing that would either confirm or refute.
Okay, so that sounds like, if I understand that, the evidence you reviewed was agnostic as to the presence of a conspiracy because there's just nothing probative to that issue.
Yeah, I'd agree with that.
Okay. Now, with respect to the information you were provided about Curtis Wayne Wright, I guess, had you received detail or a transcript of a detailed statement he gave describing what happened, would you be able to utilize that to assess the extent to which it's consistent with the crime scene appearance?
It just depends on what he had to say. I mean, he may have come up with something that just didn't fit, or he may have come up with something that was just, actually was inconclusive, or you don't know. I can't speculate because I don't know what he said.
Okay. Had you received that, do you think it could have been helpful in guiding your analysis of the crime scene?
It's always helpful.
Yeah. How about what you were provided regarding Curtis Wainwright, the notes someone took from a deposition? How much utility did you gain from that?
The notes were objective, or weren't objective.
Would that be subjective?
Subjective.
All right.
So, as far as I was concerned, what whoever wrote them wrote could have been more of an opinion.
Mhm.
And I didn't put any validity in it, really, as far as a great deal of what actually occurred. Again, that person was working for the defense, and they could have just as easily been jaded as anybody else. So, unless it's under testimony, under oath, I don't pay a lot of attention to it.
Okay. So I guess, would it be accurate to characterize Mr. Wainwright's, description of what is supposed to have occurred that night kind of a blind spot for you in your analysis of the crime scene?
Well, I mean, I don't think there were some things that you could use, but I mean, as far as the basis for an opinion, no, I wouldn't begin to use that.
I could have a moment to confer, Your Honor.
Yes, sir.
Thank you. Those are my questions for now. Thank you much.
Steve.
Good morning, Mr. Thomas.
Morning, ma'am.
Nice to see you in person.
Nice to see you.
So you reviewed crime scene photographs in this case,
I did.
2,284 of them,
Yes, ma'am.
and you reviewed the deposition transcripts of the medical examiner. Is that correct?
Correct.
You reviewed the deposition from the crime scene technician.
I did.
You reviewed a crime scene report.
I did.
You also reviewed notes from the deposition of Curtis Wright.
I did.
You reviewed an FBI lab report.
Well, I think there were several of them. It's 109 pages total.
Okay, a 109-page report from the FBI.
Yes, ma'am.
And a deposition of Detective Lebed
Yes, ma'am.
and a deposition of Detective Downs. Is that
Yes, ma'am.
correct?
Yes.
Okay. And you testified that you spent 47.2 hours on this case reviewing these materials.
Yes, ma'am.
You didn't have anything to offer that would have been helpful to Mr. Sievers's case, did you?
Not, no, I don't believe it. I would.
You have testified in over 100 cases.
Yes, ma'am.
You've been retained in over 1,000 cases.
Easily. Yes, ma'am.
Okay. In this case, after reviewing all of the materials and speaking with the defense attorneys, you noted that there was no evidence actually placing Mark Sievers at the crime scene, right?
Again, I only spoke with defense attorneys at one time, and that was after I had only looked at the first 800 photos, and then we had that phone conversation. I never spoke to him again.
Okay. But after reviewing the evidence that you were provided by them, you weren't able to find anything specifically placing Mark Sievers at the crime scene. Is that correct?
Yes, ma'am.
But you also knew that it was never alleged that he was there when the murders occurred.
Yes, ma'am.
That was never part of the state's case. Is that correct?
Yes, ma'am. Sorry.
Other than there being no evidence showing that Mark Sievers there when the murder was committed, did you have any other helpful evidence that would have aided the defense?
Yeah, that's a hard answer because I know I didn't get everything that would have been helpful. So based on what I had, I did the best I could with what I had. But would I like to have had more of the discovery that they had? Yes.
Did you ask for any additional information?
Again, at that point in time, I didn't know that Mr. Wright had already basically taken some sort of made some sort of agreement. I didn't know that he had given a proffer, so I didn't know any of that stuff. So I didn't know to ask for it because I wasn't told of it.
Okay. You testified that your approach to analyzing a case is to let me do my thing and let me tell you what I find out.
Yes.
So what did you find out from this case?
That she was attacked by allegedly two people. You can't even really confirm that. Just by the attack anyway. That could have been a single person. And that there were pry marks on the side garage door that to me didn't necessarily look like they were pried open. I knew that the allegation was, or that the theory was that this all occurred as a burglary or a robbery, but yet all these things were left out in the open, and that didn't fit to me either. So my theory is didn't necessarily, because I was told that they believed, or that they were relayed to me that the state's theory was this happened based on a robbery, per what they found out during the interviews of the defendants.
Okay. But you found nothing to confirm or refute that there was a conspiracy between Mark Sievers and the people who actually physically committed the
No, ma'am.
murder.
I did not.
If you had any additional information that would have been helpful to Mr. Sievers, you would have provided it to his defense team. Is that correct?
Yes, ma'am.
May I have a moment, Your Honor?
Yes, ma'am.
In reviewing Curtis's rights notes, you did glean that he admitted to committing the murder in this case. Is that correct?
That he was involved in it. Yes, ma'am.
Okay. And you never asked for the physical transcripts from the deposition?
I was told that that's all they had, that they never got the deposition transcript because it was so late in the game, and that's all that she had.
Okay. Is it fair to say, though, at the time you weren't going to lean one way or another on be influenced by what any one person was saying happened? You were going to do your own independent research and come to your own conclusion?
Yes, ma'am.
No further questions.
Vince.
Is this witness to be released or retained? Agree?
Yes, Your Honor.
You're free to go. Thank you, sir. Next witness.
Mr. Bob Trussell. Trussell?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Trussell.
Good morning.
Can you please state and spell your name for the court reporter?
Sure. My name is Ralph Robert Tressel. Last name spelled Tressel. I go by Robert or Bob.
And how are you currently employed?
I'm employed as a trial consultant through my company called Forensic Investigative Services on crime scene analysis.
And how long have you owned your own company?
I started the company in 2002. Ended up full-time when I retired from law enforcement.
So prior to having your own company, you had law enforcement experience?
Yes.
And can you go into your law enforcement experience?
Yeah, I went to work for the Cobb at COBB County Police Department in Marietta, Georgia in 1973 as a uniformed patrol officer. I received my post-police officer's training certificate in October of 1973. I was with the police department as a patrol officer until February of 1975, at which time I was promoted to the detective rank and I was transferred to the Crimes Against Persons Unit, commonly referred to as the Robbery Homicide Division.
Do you have any other work or specialized training in any type of law enforcement capacity?
I have several different things, yes. I stayed with the police department. I made the rank of sergeant in 1978. I left and went to the Cobb County Medical Examiner's Office. where I received advanced training in death investigations. When I took early retirement from Cobb County in 1997, I went to work for a company called Burton and Associates. Burton and Associates is a private company that handled primarily death investigations involving product liabilities. We also did homicide investigations for defense attorneys. And then in April of 2011, I returned to Cobb County as the chief investigator for the Cobb County District Attorney's Office.
How many hours in training in death investigations would you say you had?
I always estimated it's somewhere in the neighborhood of 700 to 800 hours of training between my time at the police department and my time at the medical examiner's office.
Okay. Were you ever an instructor in any type of law enforcement capacity?
I did. I was an instructor to the local police academies in death investigations, criminal investigations, crime scene analysis, and crime scene processing.
As the owner of Forensic Investigative, what do you do as a forensic investigator, consultant?
I provide consulting services to primarily defense attorneys now, in analyzing homicide investigations. It depends on what the issue is in looking at it. Is it a crime scene issue? Is it an investigative issue, evidence collection issue, or some expertise that I may give in blood spatter analysis, firearms information, particularly in I can't even talk, trajectory analysis, those type of things, and analyzing a crime scene.
Do you have further training in blood spatter analysis?
I do. I've received 2 advanced courses in blood spatter and blood stain evidence.
And you mentioned you primarily offer services to defense attorneys. Do you only offer your services to defense?
No, I do get contacted on occasion from prosecutors pertaining to primarily cases that I may be familiar with that are what I always call carryover cases. Cases that I actually physically worked on while I was in the employment of Cobb County.
What types of cases are you normally hired to consult on?
Majority, I'd have to say the majority of the cases that I get are homicide investigations.
What goes into a homicide investigation?
Well, you got many aspects of a homicide investigation. We call it putting the pieces of the puzzle together. You've got your crime scene, and that's your initial call. Maintaining a crime scene, analyzing it, documenting what you find, then the collection of whatever the evidence you have. The next thing, and I always have to say that it depends on jurisdictions, because some agencies are much better equipped to handle a homicide investigation than other agencies. So you look at the interviews that are taken, the witnesses' statements, you try to analyze those. And in a homicide investigation, you have to corroborate, or in any criminal investigation, you have to corroborate what the witness is telling you. Can we verify that they were even there, so to speak? Can we corroborate what they say they saw? And that's part of the investigative technique. Then you get the medical examiner. You have to take the information received from the medical examiner and relate it to the crime scene. What injuries are we looking at? What type of injuries? How could they possibly have occurred? And then you go back and correlate that to the evidence you found at the crime scene. And then you got some more here.
Keep going.
And then you have your laboratory reports. The information comes from the laboratory on firearms, blood stain analysis, DNA analysis. You have to combine all of that and put it together and get an idea of what it tells you about the crime scene and how things could or did happen, if you can improve procedurally what steps took place.
So you say you mainly work with homicide investigations, but it seems like it's much broader than that.
It's much broader. You have to take in the whole investigation when you look at a case.
And what type of educational background do you have to help with that?
Well, I only have 2 years of junior college, never got a degree. It was in the early 70s. I have multiple trainings. I've been trained in homicide investigations, various schools, University of Georgia, schools put on by the FBI. I have training in what's called medical legal death investigation. It's just an upload or an upgraded investigation of death investigation. And I've had two excellent classes on that. One at the University of St. Louis School of Medicine and one at the University of Miami School of Medicine. Both were 2-week schools pertaining to medical legal aspects of death investigation, how to recognize different types of death. That's part of what the medical examiner's office does. We just don't work homicides. We have all the other sundry deaths that occur within your jurisdiction that you have to investigate, determine how they happen. I've been trained in blood spatter analysis. As I said, I've had multiple courses, and 2 of them were, one was in St. Petersburg, Florida. That was the first one I attended, and the second one was in Santa Rosa, California.
And have you received any certificates after you've completed these trainings?
I've got certificates somewhere on all of them, but yes,
Have you ever been qualified as an expert in either a criminal or a civil case?
I have.
How many times?
I would estimate well over 200. I've testified in 13 states and in the federal courts as an expert in homicide investigation, crime scene analysis.
And you said the areas you've been qualified in is homicide investigation, crime scene analysis?
Primarily, yes. It deals with blood spatter interpretation in particular cases, firearms in some aspects. I'm not a ballistician. I don't look at bullets and shell casings and tell you whether they were fired by the same weapon or a particular weapon, but I look at the analysis of that information, and I'm trained through ATF in firearms investigations, just looking at the weapons and learning how they function.
Your Honor, I attend to the witness as an expert.
I don't think you need to under the rules anymore, but there you go.
Force a habit. Have you ever been, I know we talked about this a little bit, have you ever been retained or how many times have you been retained to consult or testify in a homicide case?
Okay, start that at the beginning again.
How many times have you been retained to consult or testify on a homicide case?
Oh, good gracious. In private consulting, at least 200 times, if not more.
And how many of those have been death penalty cases?
I'm having to think of the number because I do a lot of death penalty appeal cases, probably 75 plus.
When you are retained as a consultant, what do you set out to do?
Well, the first step is to set out, what does the crime scene tell us? What is the information we can glean from the crime scene? Then it depends on what the aspects of the appellate issue is, on what my function is within looking at a case. Is it looking at to verify trajectory analysis? Or is it to cause of death? Because I do get asked that quite a bit. Or is it to look at the corroborating of witnesses' statements?
And how do you accomplish those goals?
Well, first thing you have to do is understand the crime scene. You have to do an analysis of the crime scene. And then you have to look at the statements that have been given as to either eyewitness statements or investigative interviews on how the crime may have occurred. And then you have to take those statements and corroborate what the statement is telling you happened. Again, positioning, what took place on the crime scene, where certain pieces of evidence may or may not have been placed or put or found. So you have to, in dealing with witnesses, it's corroborating what they are telling you. And that's my biggest job that I'm always asked to do, is try to corroborate the statements as to what the crime scene is telling me.
And when did you become involved in the present case?
If I remember right, sometime in 2024.
And
Probably,
how did you become involved?
well, it was first by a phone call and then a follow-up with some materials from your office.
Okay. And what were you asked to do?
I was asked to review the crime scene, determine what the crime scene told us as to what happened, and then to look at the testimony of Curtis Wright to see in his testimony if certain items in the testimony could be corroborated.
Okay.
The chain of events, where they were, the different things that he said in his testimony.
And what materials were you given in order to?
Well, I had Lee County Sheriff's Office reports, their offense report, and then their investigative report. I had included in that would be the crime scene report by Kimberly Van Was. I had the autopsy report of Teresa Sievers. Then had the sworn statements of Curtis Wright. There were two of them that were sworn statements. And I had the trial testimony of Curtis Wright. And I also had all the crime scene photographs.
You've mentioned this morning your kind of main goal is to find cooperation.
Yes.
Were you able to find any cooperation in this case in your evaluation?
Yeah, there's some corroboration of what Curtis Wright was testifying to about the crime scene.
You mentioned there's some cooperation.
Yeah,
Is it
there's
fair to
some-
say there is not some cooperation?
There's some things that I have questions about that I can't corroborate.
And what are those things?
Well, gosh, I have to kind of think in order.
We could start with the initial attack, I guess, for lack of a better word, if that helps you.
Well, the one thing is I can tell you that the initial attack, if you have the photographs and you look at it from the garage into the kitchen area, there's dropping of blood over on the right-hand side, in the garage side of that countertop. And there's large drops of blood that are in that general area. And that's where the first blow was probably struck. Then there's the area to the left of that where Miss Sievers was down on the ground. I believe at some point in time she was either on her knees or on all fours, so to speak. And that's where she received the majority of the blows to the back of her head.
Is there anything about that initial evaluation that you just mentioned that you were not able to find cooperation for?
The only thing is the large blood drops, although photographed, were not measured.
And why is that important?
Well, it would tell us how high the blood drops came from. Blood reaches a terminal velocity at 6 feet. In other words, it will not gain any more speed if it's dropped from a higher height. And a single drop of blood is very distinct. And these are single drops of blood that have hit the floor. Without measuring them, it's impossible to determine the exact height they came from.
So is it fair to say that if we knew the size of that blood drop, we might be able to know what person that blood came from?
Well, we know that
The height of the
we
person
would
that
know
it
the
came from?
height that it came from. Then the question is, what did it come from the person or did it come from the weapon that was used? So it's interesting, so it can be dripping blood that comes off the weapon. When she's on the ground over to the left, between her upper legs or thigh areas of her legs, there's droplets of blood. Again, were not measured, but that's dropping blood that is single drops of blood, which is pretty much indicative of coming off of the weapon used.
Okay. Since we've mentioned blood, what is blood spatter?
Blood spatter is, well, it's a multitude of things. It's blood that has been shed or dropped. there's different types. You have blood droplets, like we talked about, just round droplets. Then you have what we call projected blood, and that's blood that is slung off. You can sling it off with your hand or a bloody object. So that becomes projected blood, what we call low speed spatter. Then you have impact spatter, which is where blood flow has already been created. And then you have an impact directly in the same general area. And we now are spattering that blood, projecting that blood at a higher speed. And it gets very small and tiny. And that's indicative in this crime scene along the refrigerator and the cabinetry just above her head. There is impact spatter there. And then you can have high speed spatter, which is from a gunshot wound. And then you have cast off spatter. And a cast off is where his weapon is used, and as it's pulled up, it'll cast off on a wall or a ceiling. And when it's brought down, it'll cast off again if it has significant amounts of blood on it. So that's what we're looking for, is what do we see?
And what value does that provide?
Well, it gives you an idea where the victim was. You can, it's especially useful when the body's been removed to try to determine where the body was and where the victim was lying. We can come back and do our angles. We can actually measure blood spatter to determine approximately what angle it struck a wall at. So we can tell you, well, it came from this particular height.
Okay. Going back to our conversation about cooperation, were there any other items or pieces of the crime scene that you did not find cooperation for?
Well, there were a couple of things. One was the damage done to the side garage door, the pry marks. The pry marks were primarily at the actual door lock, but there's no pry marks at the deadbolt.
What does that tell you?
Well, the deadbolt had to be open. There's no, if we're trying to show that you were getting in, there should be pry marks at the deadbolt. And deadbolts are exceptionally hard to open with a pry bar unless you break actually the framing. So there was a comment in Curtis's statement that he used a pry bar to do that damage. When asked in his first interview, where did you get the pry bar or crowbar? He used the word crowbar. He said he got it in the garage. There was never a question asked that I could see where in the garage you got it. What'd you do with it? And he said, I put it back where I got it. And that I can't corroborate what is he talking about. I do know that a smaller pry bar was found in the saddlebag of the motorcycle, but that was never attempted to be matched up to the pry marks on the door. Okay. And then at a later date, they found a crowbar in a yard several houses away, and that was never tried to be matched to the door. So I can't corroborate that a pry bar was used. I can't corroborate where he got it from because he can't tell me. He was never asked that.
Okay.
That I can see.
Are there any other things that stick out to you as far as lack of cooperation?
Well, he talks about that he got the hammer that was sitting on the freezer, the chest freezer that was sitting there. And we, based on the crime scene photographs, it's the hammer that's found in the garage that's covered in blood. All right. In his statement, he says that Jimmy Rogers had a ball peen hammer. And a ball peen hammer does not have a claw. And he said that the last blow struck to Miss Sievers was Jimmy Rogers using the claw end of the hammer.
Do you recall seeing any indication that a claw hammer was used?
Not on Miss Sievers. There's not a documented claw hammer injury to her.
How would you be able to tell if there was a mark from a claw hammer?
Well, the claw has got like two fingers coming down, and it's rather sharp. It's used to pull nails out, essentially. When it's wielded, it actually will leave two distinct marks. And depending on when it was used during the course of a fight, it'll dig into the skull. And a lot of times when it's pulled back out, it'll rip the tissue. And she doesn't have any injuries consistent with the claw hammer based on the autopsy report.
In your review of the crime scene, are you able to tell if one or two hammers were used?
You can't tell. These injuries are all described as having crescent shape, which is typical of a regular hammer because it doesn't hit exactly flat. It hits at an angle and creates crescent shaped wounds. I lost my train of
That's
thought
okay.
right there.
That's okay. We could come back to that. Would the person who was attacking Dr. Sievers, would they have any indications on them of the attack?
They should, whoever was doing the wielding of the hammer that was doing the damage to Miss Sievers, he should have blood on the front of his clothing, probably.
Why would they have blood on the front of their?
That's from the impact spatter, from the multiple blows. If I remember the autopsy report, there's 17 blows to the head.
And were you able to review the crime scene in relation to any testimony of Mr. Wright?
No.
Were you given any statements from Mr. Wright?
I'm sorry, my brain went wrong. Mr. Wright, yeah, I was able to correlate what he was saying about the crime scene to what we see at the crime scene.
Were there any statements that stuck out at you as possibly being inconsistent with the crime scene?
Yeah, one of the things that was inconsistent was he stated that she entered into the garage and went into the house after taking the luggage out of the car. That's all consistent with what the crime scene tells us. And he said that she walked in and she either put the pocketbook on the countertop or put it somewhere there. Well, when looking at the crime scene photographs, the pocketbook is in a chair that's on the opposite side of the counter area where she would have come to and where she was attacked at.
Why is that of significance to you?
Well, she's a very tiny person. She would have had to reach all the way across the countertop and place the pocketbook in the chair before a blow was struck. I don't know whether the pocketbook was moved, but we do know that there were a couple of items removed from apparently the pocketbook and ended up on the floor to the right of where she's found. And there's the items, I think it's a driver's license, a little billfold type thing. It is sitting on top of blood. So that had to be removed and placed on the floor after the bloodshed occurred.
And what would that indicate to you?
Somebody trying to manipulate the scene.
When you're hired to consult on a case at a trial level, is it your practice or is it common to assist trial counsel to prepare cross-examinations of witnesses?
Yes, I assist with that depending on statements and interviews, and especially when we have when from an investigative standpoint, I have questions that haven't been answered or haven't been asked, then I recommend, we try to get to the bottom of this at some point in time. So I would recommend certain things be asked of witnesses to kind of hone in on exactly what they're trying to tell us.
Is that something that could have been, that you could have done in this case?
Yeah, there's a couple of things that I would have talked about. Number one is the measuring of the blood droplets. Depending on the time that an attorney gets involved with the case, whether we can still do any work with it. The other thing would be trying to pinpoint some questions toward more towards the ball peen hammer. What happened to it? Then the other thing would have been looking at why use the claw hammer when they were supposed to be committing this murder. And then there was in a statement about that Mr. Wright gave about a traumatic brain injury. And I read through the entire file and no one ever checked to find out if that's true or not.
Why is that of importance to you?
Well, if he suffered from a traumatic brain injury, it affects you in different ways in different people. It's what is the nature of the traumatic brain injury? How did it occur? When did it occur? What symptoms was he suffering from to qualify having a traumatic brain injury? And he was never questioned about when they occurred. It was the only thing I could find. It was supposedly related to 2 motor vehicle accidents. And he said that the first accident is where he got his TBI. And that he did tell the detective that it does cause aggression on his part. And that's the extent of knowing anything about his TBI injury.
Okay, one moment, Your Honor.
Yes, ma'am.
Mr. Tristle, just going back, you also mentioned some things were cooperated with the crime scene. There was cooperation.
Yeah.
What were those things?
Well, corroboration based on his testimony was he couldn't remember where the motorcycle was, but he remembered that when the garage door opened, he ducked down behind these blue storage containers. Well, there's blue storage containers in the garage, so you corroborate that part of the statement. Now, my comment is, did he actually hide there, or did he just duck down there, or could he have been somewhere else in the residence? Definitely, whatever assailant initially made the contact, he testified that he followed her in after she was in the kitchen, and that he struck the first blow, but he couldn't remember whether he struck her from the front or the back. And by that I mean, what was she facing away from him or facing him? She couldn't remember. He couldn't remember, rather.
Is there anything from the crime scene that gives us that answer?
Well, there is a blow to the front of the head that is different from the other blows, and it's kind of a V-shaped laceration. It's not the crescent shape like the head of the peen of the hammer hitting her, and it's an unusual wound. I do not think, and I didn't find any evidence at the crime scene, the documentation or the photograph, that it would be consistent with her falling to the ground and creating the injury. So when I think about it, the best way in looking at the injury pattern, it looks like the hammer has been turned sideways, where I'm not hitting on the peen or not hitting on the claw, I'm hitting on the side of the hammer, which could cause a V-shaped laceration like she has. Now, the interesting part of that injury is it goes all the way through the tissue down to the scalp, but it didn't fracture the skull.
Why is that interesting?
It's not a full-blown blow like the blows to the back of her head where the skull is completely fractured and shattered.
Is there any other information you found corroborated?
Oh, gotta think. Well, the hammer could have been on the chest freezer. Okay, it's not there, it's on the floor, but he said it was on the chest freezer. Okay, I can take that as, okay, I can corroborate that it could be on the chest freezer. The fact that the suitcases that were left at the doorstep have been opened up and material pulled out. Curtis said that he pulled some of the clothing out and scattered it a little bit. Well, that's corroborating what we see on the crime scene. So there are periods of corroboration of some of the things that he said, and those are the big ones that come out. He said he was looking at the motorcycle. Well, there is a motorcycle in the garage, kind of parked between the two parkings. So I know that he was in the garage at or about the time, somewhere around the time that this incident occurred.
Okay. Was everything that you've testified today available? Was all that information available at the time of trial?
I'm sure it was, yes. I don't think anything new has come forward.
I'll pass the witness.
State.
Good morning.
Good morning.
You were retained in this case to specifically compare the crime scene against Curtis Wright's testimony and statements. Is that correct?
Yes,
You were asked to see if there were any inconsistencies,
yes.
but you actually did find that there were some consistencies, correlations.
I
Is
did,
that correct?
yes.
Okay. You reviewed Mr. Wright's trial testimony and from Mr. Sievers' case, right?
I did, yes.
But you did not review any other trial testimony from his case, did you?
No,
And you weren't asked to look at how Mr. Sievers' attorneys performed during the trial in any way,
no,
or what they did with the information that they had, how they presented it during the trial.
you're correct. No, I was not.
So other than the questions asked of Mr. Wright during Mr. Sievers' trial, you don't know whether his attorneys attempted to expose any potential inconsistencies about Wright's statements.
I do know that during cross-examination at the trial level, they did try to point out some inconsistencies.
Sure. So they tried to, during Wright's testimony, his attorneys tried to point out some inconsistencies, right?
Yes,
But beyond that, because you didn't look at any other witnesses' testimony, you don't know if the attorneys attempted to point out any inconsistencies through other witnesses.
no, I did not.
Okay. And you talked about the information that you reviewed in this case. I'd like to go over a few things that you didn't review.
Okay,
You never reviewed Mark Sievers' phone records, right?
no,
You never reviewed Curtis Wright's phone records?
No.
You never reviewed the trial testimony about the digital forensics in this case?
no, I did not.
And you didn't look at the testimony from the crime scene technicians during trial?
No, I didn't.
You didn't hear any testimony about how Mark Sievers acted after the murder occurred?
No,
You weren't asked to review evidence in this case beyond the actual crime scene to determine whether the evidence was consistent with Mr. Wright's testimony? Is that correct?
Okay, I missed the very
Okay,
first
so-
part of that.
Beyond the crime scene, you
Mhm.
weren't asked to look at evidence to determine whether it was consistent with Mr.
Oh.
Wright's testimony.
If we're talking about the evidence was collected away from the crime scene,
Right.
no, I was not asked to look at that.
Okay, so your only focus was the crime scene itself,
That's correct.
and you were comparing the crime scene with or against Mr. Wright's testimony.
With what he was saying about the crime scene, yes.
You mentioned that measuring blood droplets could determine the potential height of the person.
Not the person, how high the blood came from.
Okay, and that's what I wanted to get at. So if the blood was a dropping from a hammer, it would only tell you the height from the hammer that it dropped, not necessarily the person's height who is holding the hammer. Is that correct?
That's correct.
Okay. So just to clarify, it would not actually tell you the suspect's height. It would just tell you the height that the blood dropped from with a victim, or I'm sorry. It wouldn't tell you the suspect's height. Is that correct?
No, the only thing you could glean from it is sometimes when you got a large variance in heights of individuals, the drop of blood, I believe in looking at it just with without measuring device, would be difficult to be a dropped blood from Mrs. Sievers because she's so short. It had to come from a higher height. So the only thing you can determine is if this thing is over 6 feet. In other words, it leaves me a drop that's 6 feet in height. That means it could have fallen from a height even higher, which would be wielded by a taller person.
Okay.
So so that's why we look at what is the height, and then can we compare it with what we know about the crime scene as to where and how it would have come from.
Okay. But you didn't make those determinations in this case.
I couldn't.
Okay. And you mentioned that there was no documented injuries that would have come from a claw-shaped hammer.
Not
that
based on the
correct?
photographs and the autopsy report.
Okay. And other than your review of the trial testimony from Curtis Wright, you didn't know how that either came out during trial or didn't come out during trial. Is that correct?
I did not read the medical examiner's testimony, so no.
Okay. May I have a moment, Your Honor?
Yes, ma'am.
I have no further questions. Thank you.
Defense.
I have no further questions, Your Honor.
Is this witness to be released or retained?
Be released.
Say you agrees.
No objection.
You're free to go. Thank you, sir. Next witness.
Yes, Your Honor. Jennifer Wood.
Good
morning.
Good morning.
Could you please state your name for the record, please?
Jennifer Wood?
Were you ever known by any other name?
Yes, Jennifer Mummert.
And how are you currently employed?
I'm a contract paralegal.
Okay. And prior to your current employment, were you employed at the Faga Law Firm?
Yes,
And in what capacity were you employed there?
I was a paralegal and firm administrator.
And how long did you work at the Faga Law Firm before your involvement with the Sievers case?
So I started there, math's not my strong suit. So I started there in 2012. And I was there until Mr. Fega's death. But we ended up with the Sievers case in between there. So I think that was 2016.
Okay. And after Mr. Fega passed, did the law firm change hands?
Yes,
Okay. And did it become Mr. Mummert's solo practice?
so it was actually prior to Mr. Fega's death. Mr. Mummert took over the practice. And they still worked in partnership, but the actual legal transfer of the practice was right before his death. And then we were Mummert and Starling for a period of time, a little less than a little bit less than a year, and then it was just Mummert.
Okay. Let's go back to when it was the Faga Law Firm. Obviously, you worked with Mr. Faga since 2012.
Yes.
How did Mr. Faga like to work his cases? Did he have a collaborative style, or did he assign
Everything
cases?
was a group effort. We did everything. The whole office was a group effort, from consultation to everything we did. We did as a team.
Okay. So Mr. Faga would have office meetings and discuss the cases with everyone involved?
Yes.
And when I say that everyone was involved, what were the individuals who would be involved in those meetings?
So in this case in particular, it was always Mike, Tony, myself. We would bring in Al Olson, who is the investigator. And then sometimes we had law clerks, like interns from Ave Maria School of Law School. So they would be involved. But in general, like if it was just his case, not a case that Mike was working on, it would always be Tony and I.
Okay. And do you recall how the firm became involved in the Sievers case?
Yes. Tony knew somebody that knew Mark's family, and asked if we could go talk to Mark. Tony sent Mike up to the jail to go talk to Mark.
Okay. So at the point that the firm became involved with the case, Mr. Sievers was already under arrest.
Yes.
Okay. And at that time, had the state filed their death notification?
No.
Did that happen later?
Yes.
Was the firm initially hired to handle Mr. Sievers' civil issues and the criminal, or did one happen after the other?
I think they all happened simultaneously. The civil issues came later, but it was criminal and dependency kind of went together. And then later we got a trust case. And then after that, there was a wrongful death case, and a probate was somewhere in the middle of all of that. I don't have like a super clear timeline, but I know that criminal and dependency came first, and then the civil probate trust issues came after the fact.
Okay. And prior to the state's notification to seek the death penalty, were there discussions as to who was going to primarily handle the criminal case?
Yes, they were going to do it as a team effort, but
Okay.
Mike had more of the current criminal experience.
So Mr. Mummert was going to be lead because of his criminal experience at that point,
Yes,
but Mr. Faga was going to be heavily involved as well.
yes, it was a group effort.
And once the state filed their notice to seek the death penalty, were there discussions in the office as to whether to stay on the case or how they would handle it?
Yes.
And what were those discussions, if you recall?
So there was a lot of discussion about it. Mr. Fega had some hesitation. He had handled capital murder cases, but in New York, they didn't have the death penalty, so that was not, and that was many years ago. So there was discussions as to we needed to have somebody who was death qualified. We needed to start looking for that, and that ultimately we would talk to Mr. Sievers about it.
Now, was there a search for a death qualified attorney? If you
Yes.
were. And ultimately, was a death qualified attorney found for this case?
Yes, so we had interviewed a couple, and then I'm pretty sure that in 2017 it was, maybe mid 2017, Mr. Masori reached out to our offices.
Okay. And you discussed that also Mr. Faga and Mr. Mummer were going to discuss whether to stay on with Mr. Sievers.
Yes,
And was it Mr. Sievers' choice to keep you on the case?
yes,
And I believe you just testified that Mr. Masori became involved in 2017. Is that correct?
yeah, I can't remember exactly when in 2017, but I know that it was prior to Mr. Faga's death. I know Mr. Faga was involved in those initial discussions with him, so it was prior, even before he got sick and wasn't really actively involved in the practice.
Okay. And did Mr. Masori reach out or did the firm find him?
No, he reached out to us.
Now, did Mr. Faga or Mr. Mummer seek advice as to how to themselves prepare or get death qualification to handle this case?
Yes, we did.
Okay. And who did Mr. Mummer or Mr. Faga reach out to for that?
When the initial notice of intent to seek death came about, we went over to Miami, and I'm not going to remember the law school, but it was a Miami law school where they had a death clinic. They had the clinic there, and we spoke to a few different death attorneys there who definitely advised us to start talking to death qualified attorneys. And then we went to Life Over Death 2, maybe 3 times during each year we went to Life Over Death after that. And then Kathleen Fitzgeorge was very helpful in terms of guiding.
Okay. And did Kathleen Fitzgeorge represent one of the defendants in this case?
Yes,
And who was that, if you recall?
Jimmy Rogers.
And in the initial stages, did the team at your office and Ms. Fitzgeorge collaborate on depositions and work together?
Until this severance, we did everything together, yes.
And she provided insight for Mr. Mummer?
I would say more guidance, yes.
Now, was your firm advised to hire a mitigation specialist?
Yes,
And what was that process like for your firm?
painful. It was really painful trying to get one. So early on, Mr. Faga was focused on that. We had multiple interviews and phone calls with people that were originally recommended to us over on the other coast. I want to say like one was in Delray Beach. And basically everybody told us we can only have a certain amount of cases. We're at our max capacity. Call us. The 3 women that we had interviewed and talked to that we really liked were like, hey, we're at our max right now, but try again. We'll let you know if one falls off. Then we hired Cynthia O'Shea,
Okay.
was the first one that actually got on the case.
Okay. And she was the first mitigation expert that became involved in this case.
Yes.
Okay. And from the way you're describing it, it sounds like in these initial stages, Mr. Faga was very involved with trying to find a mitigation specialist. Is that correct?
Yes, he did all of the interviewing in that beginning.
Okay. And how long did Ms. O'Shea work on the case?
I'm not sure. It was a couple months, probably a little bit longer than that.
Okay. And why did she stop being a mitigation specialist on the case?
She had billing issues with the JAC and she was no longer allowed to continue with the case through the JAC.
Okay. So the firm had to restart the process again?
Yes.
Okay. And did the firm eventually hire Miss Donna Murray?
Yes.
Okay. And when did the firm hire Miss Donna Murray to be involved in the case?
I don't know exact dates. I know that we tried to get those ladies back again that we had previously interviewed. We called them again. And then we ended up with Donna Murray. I would say maybe, I don't know, August of the year, maybe August of 2018.
Okay. Roughly August of 2018.
I'm guessing.
So it was right before trial was set to be.
It was shortly, yes. We were definitely panicked about it. It was close to trial.
Okay. And during this time period and during the pendency of the case, were there still attempts made by the firm to collect mitigation information and interview witnesses to prepare for the penalty phase?
Yes. So Cindy O'Shea had given us kind of like her initial documents. So myself and Al Olson tried to chase down all the documents and that kind of thing to make it easier for whomever took over.
Okay. And when you say that you and Al Olson went to go chase these documents, what did you do? What efforts did you make?
So I know Al Olson went at Thanksgiving time, 2017. There was depositions being done in Missouri. He went to Missouri and interviewed witnesses. I know that in 2018, I went to Missouri myself to get a bunch of records. That was in May. We were having difficulties with people responding appropriately to getting records and the back and forth with different court systems and that kind of thing. So I flew out to Missouri myself to get them.
Okay. So you were very involved in the mitigation process.
Yes.
Okay. And when Miss Murray joined the team so late in the game, did you provide Ms. Murray the documents that she needed?
They were all through the Dropbox.
They were all through the Dropbox. Were there issues with the Dropbox?
She claimed there was. I had never had anybody else have issues with the Dropbox.
Okay. But she had issues accessing the information?
She had sent us an email saying that the Dropbox link was empty. She couldn't access it. It wasn't a good link.
Okay. Did she also raise concerns about the length of time before trial that she had to work?
I think right at the end, right before she left, that was her reasoning of not staying on the case, was that this was just too quick and there wasn't enough time.
Okay. Okay, and there was email correspondence regarding this?
Yes.
Okay, and you would respond to Ms. Murray regarding her concerns?
Yes.
Okay. Were you the primary person responding to Ms. Murray?
Yes. I know the final response, Mike and I had talked about it and then I sent the final response to her.
Okay, and that was ultimately to cut her out of the case?
Well, she was the one who said she wasn't going to move forward because she didn't have enough time.
Okay. Would it be fair to state that you liaised a lot with the mitigation experts in this case?
Yes.
And is that because as part of your role in the office as the administrator, you organized the records?
I did a lot of the scheduling, organizing of records, keeping of all the discovery, that kind of thing.
Okay. And speaking of the collecting of records and the organizing of records, how did the firm do that? Was there a specialized room where the physical records were kept in?
So we had a room that was all just those files that was locked. And it was only the hard copies. And then we also kept in there the original. At the time, we would get the discovery from the state on CDs. And so we'd keep all the original CDs in the way that they came from the state. So I would take them and then put them on a hard drive when we get them. And then those original CDs were also kept in that room.
Okay. And placing the information on hard drives, was that to make it easier to locate the information?
So I organized it in my own fashion, not the way the state gave it to us. So we separated out the documents, retitled them, and I had like a working hard drive so that we still had all the original data. And then and all of it was also on a backup on Dropbox.
And if any of your experts requested information, would you give it to them physically or digitally?
Everything was in Dropbox, but if they requested anything additional, like sometimes they would say like, I can't find this, and I would typically do it digitally. I think Al Olson would come to the office a lot because he liked the hard copies, so he would work out of the office a lot of times, but everybody else was pretty much digitally.
Okay. And when Mr. Missouri became actively involved, did he have access to the records at your office?
Absolutely.
Okay. Was he also given records digitally?
Yes.
Once Mr. Missouri became more actively involved in the case and Mr. Fega passed, how did the trial team function and the office function at that point with respect to the Sievers case?
So Mr. Missouri would come to the office, like when we tried to have pretty regularly scheduled meetings with the whole team. So Al Olson, Marie Olson, Mr. Missouri. Eventually we added on a mitigation specialist, Mr. Giordano, myself, Mike. We would have like a pretty regular all office meeting. But like the day-to-day stuff was handled typically by Mike and I. And then I remember like he would leave court, Mr. Missouri would leave court and be like, hey, can I come by the office? And yeah. And so he would just come by.
Okay. Now, did Mr. Missouri regularly keep contact with the mitigation experts in this case, or was that all handled through you?
I think not with Cindy O'Shea. I don't think he had any contact. Maybe once with Donna Murray, but he did with Jeff Giordano, I know for a fact.
Okay. And ultimately, was Jeff Giordano the final mitigation specialist that your firm hired on this case?
Yes.
Okay. And was he one of the experts that you had attempted to contact previously, or did he come from another list of experts?
We did not try to contact him immediately. He came from the JAC's list of people.
Okay. And once Mr. Giordano was on the case and became involved, what did he do as a mitigation specialist on the case?
So we gave him Cindy O'Shea's, Donna Murray's records, all the records I obtained. He had access to the Dropbox as well. I know that he interviewed Mr. Sievers several times. He interviewed a series of witnesses in the family that we had asked him to interview. I don't really know. He was kind of hard to keep track of what he was. He didn't work as directly with me. Once he took over the mitigation, it wasn't as direct until we'd have those meetings. So like I wouldn't know who he was interviewing or that kind of thing on a day-to-day basis. But then when we would meet, he would give his updates.
Would it be fair to say that the collaborative atmosphere that had prevailed under Mr. Faga kind of disappeared afterwards, once he was gone?
I think the collaborative effort became more of Mike and I and Al Olson. It was very, very involved. I think it became more of us. It was like a smaller group than what we originally had. And then right before trial, everybody worked together before we had on those final preparations.
All right. And were there other experts hired on this case?
Yes.
Was there a crime scene expert hired on this case?
Yes.
And who was that?
JD Thomas.
And what was the purpose of Mr. Thomas's involvement in the case?
The initial idea was to give him all the crime scene photos, and Mr. Fega had said day one that he did not believe that the story, the narrative matched the forensics. So we wanted to see what a crime scene expert would say. And then eventually, as Curtis Wainwright was making his statements, we wanted him to disprove those statements with forensics.
Okay. And do you recall when you hired Mr. Thomas?
I don't.
Okay. Is Mr. Thomas someone Mr. Fega used previously, or was he recommended?
I think I met him at one of the Life Over Death conferences.
Okay. And that's how he eventually became involved in this case?
Yes, I asked around and everybody said he was great to use him.
And did you contact him on behalf of the attorneys?
Yes.
And did Mr. Mummert speak with Mr. Thomas?
Yes.
Okay. How many conversations?
I remember one right leading up to a trial. And then I think we had like a few where I was talking to him and Mike would come participate in the conversation. But like I remember them having one meeting.
Okay. And the reason behind getting Mr. Thomas involved was because Mr. Fega felt that Mr. Wright's statements did not fit what he was seeing in the crime scene and the forensics.
Yeah. Well, Mr. Fega said in the beginning that the police narrative did not fit the crime scene. That was before Mr. Wright even started making statements. So Mr. Fega did not believe in the beginning that the forensics and the narrative were matching.
And what information did your firm develop from Mr. Thomas?
That the narrative did not match the crime scene.
Now, was he ultimately used at trial?
No.
Okay. And do you recall why not?
Mr. Mummert made that decision at trial. He believed that the detectives themselves gave enough information. I believe one of the detectives testified something like, yeah, he thought it was bizarre that there wasn't the same amount of blood spatter that you would have expected to see, or he thought that he got enough out of the detectives that he chose not to call him.
Okay. And this was a decision made at trial?
Yes.
And was Mr. Thomas under subpoena at the time?
No, we had just told him, hey, we might be going to trial. He had a conflicting date too. He was trying a case. He was in a trial up in North Florida at the time. I don't remember where, but I stayed in contact with him through phone communication.
Okay. Were there other experts hired to look at this case for mitigation purposes?
Mitigation, yes.
And do you recall who those experts were?
We had a mental health expert. Can't remember his name. He was a doctor. I can see him. I don't remember his name. He's out of Arizona though, out of Phoenix, Arizona.
Okay. Did this doctor evaluate Mr. Sievers?
Yes.
Okay. And was this done confidentially, or did you list him as a witness?
I think he was eventually listed as a witness.
Ultimately, Was this person used at trial?
No.
And was that Mr. Mummer's decision?
I think him and Mr. Masor made that decision.
Do you recall if there were ever any discussions during the team meetings to try and speak with Mr. Rogers?
I remember Mike asking Kathleen in like a passive, like, is your client gonna let me talk to him type thing, like a more of like a joking, passing type conversation. And she was like, yeah, no. But there was never like an actual discussion to talk to him.
Okay. And regarding, you testified earlier that Mr. Mummert and Ms. Fitzgeorge were working together in preparation for trial, but ultimately this case was severed. Did Mr. Mummert know Ms. Fitzgeorge would be filing to sever the case?
No.
Okay. Did that come as a surprise to the trial team?
Yes, we did not know that that was filed in Mr. Rogers' case. We just saw the order come across from the judge that the case was severed. And then we pulled Mr. Rogers' docket and saw that there was a motion.
Okay. Up until that point, what was the understanding of what was going to happen at trial with Mr. Rogers and Mr. Sievers?
So I think the plan was that they were handling more of like that forensics piece as it pertained to Jimmy Rogers' case, more so than it pertained to Mr. Sievers' case. So they had their experts. We were kind of relying on Mr. Mummert was more focused on the conspiracy piece of it than the forensics piece.
So at some level, some of the forensics and the development of that evidence, Mr. Mummert was relying on what was coming out of Jimmy Rogers' case.
Yes.
And ultimately, Mr. Rogers' case went first. Is that correct?
Yes.
Okay. Did Mr. Mummert send anybody to attend that trial?
I attended the trial.
Okay. On behalf of Mr. Mummert?
Yes.
Okay. And did you take notes at the trial?
Yes.
Was there ever discussion at the office of obtaining transcripts from that trial to prepare for Mr. Sievers' trial?
Yes, I believe we ordered several transcripts.
Okay. And did you also attend along with Mr. Mummert the deposition of Curtis Wainwright?
Yes.
And were there discussions about obtaining those depositions?
We obtained those.
Were there discussions at the team meetings about how to handle Mr. Wright's testimony at trial?
Yes.
Was Mr. Mazzora involved in those conversations?
Towards the end, he was, like right before trial, he did participate, but not in the beginning when we first, so we did it visually first and, kind of wrote it out. And then we started developing the questions using the depositions. And I think he came in after that initial development of that.
Okay. And did he help Mr. Mummert and provide insight as to how to properly attack and impeach Mr. Wright's testimony?
Not that I recall.
Did Mr. Mazzora also provide insights as to the jury selection on this case? What was his participation for that?
So I know he participated. He was at the table with Mr. Mummert. We had sheets that were developed. I don't think he did those as well. I think he took his own notes, but he communicated with Mike about it.
Okay. And how did Mr. Mummert prepare for jury selection on this case?
So we took at one of the life over deaths. I think I don't know what the method's called now. I want to say the Morgan method, but at the time it was the Colorado method. So we went and took those seminars. And then we did like mock jury so he could practice it. And then we developed I don't know if you want to call it like a score sheet. Like it was like a 1-page sheet that we would all fill out to get that to the rating system. And so we all practiced that to make sure that we were kind of aligned in the same scaling.
And that is what Mr. Mummert used ultimately at trial?
Yes.
If I may have a moment, Your Honor.
Yes, ma'am.
Okay. Okay. Would it be fair to say, Ms. Wood, that you were the main point of contact for a lot of the experts, between the experts and the office on the team?
Yes.
Did you sort of act like a filter or a conduit for those individuals to the lawyers?
Sure. Yeah, that's
But obviously, whatever was done with those experts would be done at the behest of the attorneys.
yes. And they were always copied on all communication and
So they were always aware of what communications were going on.
yes.
And with respect to Mr. Giordano, is he based in Miami or was at the time?
Yes.
Okay. How did he participate in the team meetings?
So he came in right at the end to prepare the mitigation. So leading up to the trial, we prepared like an initial mitigation packet presentation. And then after the conviction, after he was found guilty, we spent a lot of time with Mr. Giordano preparing for the next phase. So he was present there. We created PowerPoints. We put together witness questions. We prepared the whole piece.
Okay. And all of this preparation was done to assist Mr. Missouri in the presentation of the penalty phase?
Yes.
And at that time, Mr. Giordano would come all the way from Miami in person to assist with this?
Yes.
Okay. And he assisted in putting together what you described as a mitigation package,
Yes.
including a PowerPoint presentation?
Yes.
Okay. Was this PowerPoint presentation ultimately used at the penalty phase?
No.
Did Mr. Missouri decide not to use it at trial?
Literally minutes before we walked out here, he decided not to use the PowerPoint or the outline that we had developed.
Okay. Did he participate in the development of that presentation?
So we developed it, Mr. Giordano and I developed it, and then he had I think his name was Jose, maybe. I'm guessing on his name, but another gentleman that worked with Mr. Giordano's office that came over and helped with like the graphics of it or whatever, because we had older pictures, so we needed to change that. So he helped with that piece of it. And then we brought Mr. Missouri in after that was all developed. He had us make changes to it. We moved slides for better flow or whatever. And he was involved in that, but not the actual development of it.
But he did have input as to how it would look like, how it would flow.
The flow, yes.
Okay. And in this PowerPoint presentation, what information was being conveyed?
It was a timeline of Mr. Sievers' entire life from childhood, living in the islands with his dad while his dad was in medical school, to his parents' separation, all the way through college, having children, the whole timeline.
So it was a step-by-step presentation of who Mr. Sievers was.
Yes.
And do you recall what the main theme of the mitigation that was going to be presented at trial?
So we didn't have any of the statutory mitigators, so we tried to really focus on his life, that, you know, he was a good family man, that he was a good father, that he gave back to the community. He did a lot of charity stuff with his daughters. It was really focused on that, but it gave the whole picture of his life.
Okay.
Divorced parents.
Did Mr. Mastori use any of that information at the penalty phase?
No.
If I may have just one moment.
Yes, ma'am.
At this time, I'll pass the witness, Your Honor.
State.
Ms. Wood, good to see you. It's been a while.
See you.
So let me just first, I want to clarify for the record the use of the title paralegal. Is your job title paralegal, or are you a Florida certified paralegal?
Job title is paralegal.
So you're not a bar certified
No.
paralegal, okay. Is it safe to say that you were very involved in Mr. Sievers' defense?
Yes.
You were interfacing with the defense attorneys. You were, yes?
Yes.
You were interfacing with the defense experts.
Yes.
You were interfacing with the Rogers defense team.
Yes.
You were even interfacing with me and my staff at my office on a regular basis, right?
We did a lot of arguing about discovery. Yes.
And you challenged us to make sure we were producing it the way you needed it produced, and we challenged you to take it the way we were giving it to you, right?
Yeah, we did a lot of that.
We did a lot of that. Ultimately, you were able to get all the discovery from us,
Yes.
and you were able to provide all the discovery for use by the attorneys in the firm.
Yes.
Mr. Mummert and Mr. Faga both understood clearly that they weren't death qualified, right? And they explained that to Mr. Sievers.
Yes.
Mr. Sievers understood that.
Yes.
They were very upfront with him and with the court about their qualifications, right?
Yes.
There was nothing about it that was hidden, correct?
Correct.
And despite all of that, again, Mr. Sievers wanted to keep the team.
Yes.
And the team sought out assistance in defending a death penalty case, right?
Yes.
Was it FIU law that they went to?
That sounds right.
Right? Sounds about right. Spoke to some professors at FIU law, right? Spoke to, you mentioned earlier that Mr. Mummert spent some time talking to Ms. Fitzgeorge, who has very distinguished death penalty trial record, right?
Yes.
And you said we went to life over death. Now, does that mean the firm went or you went along with the attorneys?
Al Wilson went. So the first year it was Mr. Faga. He was alive and well. Mr. Faga, Al Olson, I think maybe even Marie Olson went, myself, Mr. Mummer. That was who went to the
So-
first one, and I don't remember the second one. I think Tony was sick at that point and didn't go with us, but Al, Mike, and I went.
So not only did Mr. Mummert and Mr. Fago go as the attorneys, but the non-attorneys, yourself, Mr. Olson, Mrs. Olson, also went.
I can't remember if Maria also went or not, but yes, we did.
And you were able to apply some of the principles that you learned at this seminar to your defense of Mark Sievers, right?
Absolutely.
Mr. Mummert and Mr. Faga consulted with and hired mitigation experts.
Yes.
Mr. Mummert and Mr. Faga consulted with and hired a crime scene expert.
Yes.
Mr. Mummert and Mr. Faga consulted with and hired, I think it was Dr. Underwood to do,
Johnson.
Dr. Underwood from Phoenix, right?
Yes.
To do the mental evaluation of Mr. Sievers.
Yes.
And again, the purpose of that was to find out if there was any information to assist in mitigation for Mr. Sievers, right?
Correct.
Mr. Mummert participated in depositions of not only the state's experts, but as well as when the state deposed the Rogers experts. Mr. Mummert participated in those depositions, right?
I'm not sure if he participated in all of them, but I know that we made an attempt to go to all of those.
And when y'all went to Missouri, did y'all go on your own dime or did you have court funds to pay for that trip to Missouri?
We went on our own dime.
So you went on your own dime to find documents to not only investigate, but to potentially be able to present in court in Mr. Sievers' defense if necessary.
Yes.
And Mr. Olson interviewed potential mitigation witnesses in Missouri
Yes, he interviewed several witnesses.
or trial witnesses.
For both. Yeah, it was purpose was for both.
So Ms. Murray, and both you and Ms. Murray have said that there was an issue, whatever the issue was, with her Dropbox link. Now, were you the person who was in charge of farming out the Dropbox links to the appropriate experts?
Yes.
Were you pretty adept at using Dropbox?
Used it a lot in that case.
And did you have to become very adept with working with digital files, PDFs, and things like that?
Yes.
You provide the Dropbox information to JD Thomas and he was able to use it, right?
Correct.
You provided Dropbox information to the gentleman from Miami, Mr. Giordano, and he was able to use that, right?
Correct.
And did you also provide the Dropbox information to Cindy O'Shea
Yes.
and she was able to access that?
Yes.
So somehow Miss Murray was the only person who seemed to have that problem.
Correct.
When she discovered the problem, did she immediately inform you about the problem or was there some delay?
I believe there was a delay, but that was a communication barrier apparently between her and I.
Safe to say, to this day, you don't agree with Miss Murray's exit from the case and her reasons why.
Correct.
If Miss Murray needed documents, discovery, or anything from your office to enable her to prepare Mr. Sievers' mitigation, would you have attempted to obtain that for her?
Absolutely.
Did you also spend a lot of time talking to Mr. Sievers about the case?
Yes.
Now, is it safe to say also that Mr. Mummert, once the experts were briefed and supplied with documents, that he expected them to do the work on their own?
Yes,
Mr. Mummert wasn't necessarily into hand-holding the experts, right?
no, he's not a hand-holding kind of lawyer.
Not the hand-holding kind of guy.
I am.
But so once they were employed and given the documents, he expected them to go do the work and report back on what they found, right?
Correct.
And he used you as the liaison between him and the experts.
Correct.
So the fact that Mr. Giordano took his mitigation packet that was provided to him and Mr. Mummert maybe didn't know what he was doing with it, it wasn't a problem for Mr. Mummert, right? As long as Mr. Giordano reported back.
Yeah, I would say that's correct.
Mr. Mummert was ready and able to call Mr. Thomas as a witness at trial, right?
Yes,
He made a tactical decision not to.
correct.
And let me double back. I think I passed the subject here, talking about jury selection. Not only were you present here when we did I think in that seat over there, when we did the Rogers trial, you were also present here for the Sievers trial, right?
Correct.
And you were able to provide advice and assistance to the defense team you were part of the defense team during the Sievers trial, right?
Correct.
Even though you weren't sitting in the well, you were participating in the defense, right?
Correct.
And you were able to provide your insights on jury selection as it occurred, right?
Yes, I sat back there under the AC vent.
Way in the back where it was cold.
Yes.
And it was up to the attorneys and Mr. Sievers to decide whether or not to use your insights, right?
Correct.
Despite the fact that, well, in fact, getting up to the severance, the defense teams up to until the severance was filed, I'll say the parties have been planning to do a joint trial, right?
That was our belief. Yes.
We collaborated on Venari questions for the jury,
Yes.
right? We went back and forth on questions, planning for a joint trial, right? And so when the severance surprised Mr. Mummert, did he have time to adjust?
Not a lot of time.
Certainly it would have been a lot less time for him to adjust if the Sievers trial had started first in the beginning of October 2019, as opposed to the Rogers trial, right?
Yes.
And you said that at one of the death penalty seminars that you and the team attended, you learned the Colorado method of jury selection.
Yes, that's what it was called then. I think they've changed the name now.
We'll say whatever it's called.
Yes.
You learned the method that was being taught at one of the seminars.
Yes.
And the team worked with Mr. Mummert to practice this method.
Correct.
Only once?
No,
More than once.
absolutely.
And this was something Mr. Mummert and the team took seriously.
Yes.
So you spent a lot of time with Mr. Giordano working on this, and the other gentleman, I think you said his name was Jose something, working on this PowerPoint.
Correct.
You were very invested in the PowerPoint.
It told our whole timeline, so yes.
A little disappointed maybe that it wasn't used the way you thought it should have been used in the mitigation part of the trial?
Yes.
But in fact, Mr. Masori did review the PowerPoint, right?
Yes.
He knew what was in it, right?
Yes.
In fact, he used elements of the PowerPoint in mitigation, didn't he?
Maybe some pictures that we had, like the larger blown up version of them, maybe some of those.
The pictures, the ones of him in the islands, Mr. Sievers,
Yes.
graduation pictures,
I don't remember about graduation pictures.
the family pictures.
Family pictures, yes.
So even though the PowerPoint wasn't used in its entirety, Mr. Masori knew what was in it and was able to incorporate elements of it into his defense, right?
Not in its entirety, no. There was large portions of that that were not used.
I use the word elements. He was able to incorporate parts of it. I'll
Yes.
use a better word, parts of it into his defense.
Yes.
Certainly you would have liked to have seen the whole thing used, right?
Yes.
You put a lot of work into it.
Had nothing to do with the work being put in.
Okay. Thank you.
Defense.
Briefly, Your Honor. Now, as you testified to the case, you liaised a lot with the experts, is that correct?
Yes.
And you would convey to the attorneys what those experts were saying, what they were reporting back.
Yes.
And they were always, if it was an email communication, they would always be copied, correct?
Correct.
And in this matter, with Mr. J.D. Thomas, did he provide useful information for the Sievers defense?
Yes.
But ultimately, Mr. Mummer opted not to use him.
Correct.
Now, would it be fair to say that you learned a lot about mitigation as this particular case went on?
Yes, I knew nothing in the beginning.
Did Mr. Mummer know a lot about mitigation prior to getting on this case?
He knew that it was required, but and I think a generalized idea, but until we went to that first life over death, I don't think either of us were truly, same with Mr. Vega. I don't think any of us really knew.
So it would be fair to say that you learned a lot about what kind of information needed to be developed in mitigation while this case was pending.
Yes.
Okay. And you went to a lot of trainings for that.
Yeah, we went to the life over death.
Yes. And you said that you went to the life over death more than once while this case was pending.
Yes.
And now, as part of your duties with record keeping, you testified earlier that you would receive the records, you would maintain a copy of the records as they were, but then you would organize the records in a certain fashion. Did you ever rename the records or the files?
Yes.
Okay. And what were the naming conventions in the Sievers case relating to the records or files? Like, how would you label them?
So I would typically label what it was and then what the bait stamps were, because we had a lot of issues where like we'd say that we were missing things, and so we'd get like a new discovery dump, for lack of better terms. And when we get that, I would try to track the baits to make sure that it was all the same exact stuff that we had gotten before. And then we had like a log, created a spreadsheet log. So it was how the state had it labeled and then how we relabeled it. And then if it was reviewed by Mike or not, so he knew what he had reviewed and what he hadn't. But it would typically be like whatever the document was, and then it was separated by each thing. So when we would get it from the state, it would be like pages 2,000 to 6,000, and it's a little bit of everything combined in it. So we would separate it out, and I would separate those files into separated. These are photos, these are phone records, these are each of the individual things.
Okay. So in other words, this was a very voluminous case.
Yes,
And the way you broke it down was to assist Mr. Mummert in his review.
yes, and the experts.
Okay, and the experts. And you would clearly label if it was a crime scene report.
Yes,
So there would be no mistaking as to what they actually obtained through the
Correct.
Dropboxes.
correct.
Mm. Okay. And obviously you would also maintain a list of what you gave the experts.
I don't think I maintained a list of what I gave them as much as I gave them access to the Dropbox. And so I could see when they would open like their little pictures, like the picture of them, it would say like last viewed on with like their little icon.
Okay, so you could track to see who accessed it and when.
Yes,
Now, you also testified that Mr. Mummert did a lot of preparation for jury selection and did almost like mock jury selections.
yes,
And that was to familiarize himself with the jury selection method that was being taught at the time.
yes.
Okay. Did Mr. Missouri participate in this preparation?
No,
Okay. So he did not participate in the mocks to assist Mr. Mummert on this?
no,
Okay. But he was present during jury selection to give his insights.
yes,
Now, was now, I believe you testified earlier that that once Mr. Fega passed away, it sort of became a much smaller circle of people who would meet and collaborate on the Mr. Sievers case. Is that correct?
yes,
It would be mainly yourself, Mr. Mummert, and Mr. Olson,
yes.
and Mr. Giordano at one point.
In the mitigation phase, yes.
And that was closer towards trial.
Right before trial and then after the first phase of trial.
Would it be fair to say that Mr. Missouri wasn't always present for all of those meetings?
No, he was not.
Okay. Would it be fair to say that he was a little less involved than Mr. Mummert?
Absolutely.
Objection. That one's leading.
Sustained.
What do you recall was the level of Mr. Missouri's participation in those meetings?
So when he did come to those meetings, he was more focused on the mitigation aspect of it. So he didn't really participate much up until right before trial. And then it was kind of like, we already had our binders prepared. We already had our witnesses, you know, what we planned to talk about the witnesses. We already had the exhibits. So he just kind of reviewed with us right before trial.
So from what you observed, he reviewed items prior to trial. Is that correct?
Yes,
Okay. But in the preparation, he wasn't nearly as involved.
correct.
And you also testified regarding the slideshow when Mr. Hunter was questioning you, that there were portions of the slideshows that were not used.
Correct.
And I believe you characterized it as large portions. Is that correct?
Yes.
I have no further questions.
State.
Nothing further from the state.
Is this witness to be released or retained?
Release.
Agreed?
Agreed.
Thank you. ma'am.
Thank you.
You're free to go. How many witnesses do you have left for today?
We have two witnesses and then Mr. Rogers.
Okay. Your next witness, I'm assuming, is longer than 10 minutes.
Potentially, and I would ask the court for me to check if they're there and talk to them for a few minutes anyway.
Well, I guess what I'm getting at is, should we break for lunch now, or
This
You wanna
might be a good time to break for lunch.
agree?
Agreed, Your Honor.
What do you think? 1:15? 1:15?
Thank you, Your Honor.
Should give everyone enough time.
Thank you, Your
Okay.
Honor.
See everybody then.